Swayam Prabha. Digital India. Educated India.
Good morning viewers, this is Dr. Ashwini Siwal from Faculty of Law, University of Delhi, and I am here to discuss a very important intersection of law, science and technology. This lecture is basically on law relating to drones in India, primarily in India, and few underpinnings of the international arena we will also look at. But predominantly this lecture will revolve around the law relating to drones in India, and this is lecture number 5 of this lecture series called Law, Science and Technology. My dear viewers, you all know that of late the drones are used for multifarious purposes. They do not have only defense utility, or they do not have the restrictive utility only in the defense sector. Rather, the drones are being used for several things like surveillance, for capturing images, for delivery, for even supply of the medical equipments or medical supplies at the times of emergency, and so on and so forth. But how this particular medium, which is very expeditious and which is very swift, is regulated by law, and what are the different laws which may get attracted in governing this particular medium called drones? Well, viewers, there is no one particular set of law or one particular law to regulate the drones or their prevalence in the country. There are various laws which get attracted, or which, as as a chunk, answers several questions which are arising, some legal questions which are arising in the use of the drones. Now, many of you must be wondering how even kids or teenagers are using drones and flying them in your neighborhood, how the drones are being used in the marriages for capturing the images, what are the legal issues surrounding these things. These are the questions which will perhaps get addressed in today's discussion, and moreover these similar drones may further be used for some criminal activities. They may be used probably for causing some kind of espionage, or conducting some kind of espionage or surveillance. So, there are different issues and very complex issues pertaining to drones, which have very complex legal answers as well as very complex legal provisions involved. So, today's lecture is an attempt to describe those laws and those legal questions, and then see what is the way forward to regulate the drones in a very appropriate manner. So, let us begin, my dear viewers. If we want to really know about the legalities here and the legal answers to those legalities, I will quickly give you the brief introduction about the history of the drones in India. Well, the Indian Army was the first to acquire unmanned aerial vehicles. These are called unmanned aerial vehicles in the late 1990s, and the Indian Army brought these vehicles from Israel, and the Indian Air Force and Navy also followed the suit. They also later on started using the drones. So, this is how drones were brought in India from Israel. First used military drones during the 1919 Kargil war with Pakistan, and the Indian force deployed manned English Canberra PR-57 aircraft for photo reconnaissance along the line of control at the time of the Kargil war, but this system proved highly inefficient and strategically weak over the mountainous Kargil terrain. We all know that the terrain in the Kargil is very difficult, and it is mountainous, and uses of a drone in that particular domain or that terrain is very difficult. So, our experience in the 1999 Kargil war of the usage of the drones was not very good or was not encouraging. After India lost Canberra PR-57 to Pakistani infrared homing missiles, Israel discreetly supplied the Indian Air Force with the IAI Heron and Searcher drones, which were useful for acquiring target information along the line of control. So, Israel has been supplying us, had supplied us latest or updated drones later on after the failure of the Canberra PR-57 into the Kargil war. So, this is how the usage of the drone started in the country. Since Kargil, India has procured numerous Israel military unmanned aircrafts. In 2009, the Indian Air Force purchased 10 Harrops in 100 million contract with Israel Aerospace Industries. In 2013 as well, the Indian Air Force made a $280 million deal with Israel Aerospace Industries for a new series of Heron medium altitude long endurance drones. So, basically the emergence of the drones in India is primarily by the military, or by, you may say, by the defense sector in India. It was not primarily brought here in India by the private entities, and Israel has been the main supplier of the drones in India, right. Moving ahead, in 2013, India began deploying Heron surveillance drones in a limited capacity over Maoist rebel strongholds in the east. Such activity has been limited to Andhra Pradesh, Odisha and Andhra Pradesh, Chhattisgarh. These states are densely forested. So, the unmanned air vehicles have been of little use in reconnaissance and surveillance. Even the drones which were deployed there in the Maoist affected areas, those were of no help or was not of great help, right. Back in 1990s, the army brought Israel drones for recce and surveillance, but in 2019 India procured 15 4 Harrop attack drones from Israel. The Air Force already had an inventory of around 110 of these drones. So, we have a primary history of the army bringing drones. What is very encouraging to observe and to discuss here is that DRDO also develops its own domestic unmanned air vehicles, and they have one project which aims to develop a domestic arsenal to replace and augment the existing fleet of unmanned vehicles. And we have some good examples where DRDO has introduced Lakshya, which is unmanned vehicle. This is a target drone used for a discrete aerial reconnaissance and target acquisition. Then DRDO Nishant, which is primarily designed for intelligence gathering over enemy territory. We have DRDO Aura, similar to the Lockheed Martin RQ-170 Sentinel. This is a stealth drone capable of releasing missiles, bombs and precision guided munitions, right. DRDO Rustam is another model after the American Predator, and this Rustam is a medium altitude long endurance system, right. It is designed to be used for both combat as well as for surveillance or reconnaissance, or you may say for taking pictures along the line of control. It is expected to replace and supplement the Israeli Heron model in the Indian Air Force. So, now we have our own indigenously made drones which are going to replace the Israeli drones in no time. Well, so far as military use is concerned, we know that there has been the military use, rampant military use of the drones or for the purposes of surveillance and for the purposes of even bombing, etc. But how this use of military or military use is turning to civil use, this is very interesting because when it turns to the civil use, it becomes more ill regulated and there are very less legal regulations, but over the period of time we have brought new legal regulations which are now governing the drones or the questions, legal questions pertaining to drones. So, though these unmanned vehicles were originally developed for the military and aerospace industries, now drones have found their way into the mainstream because of the enhanced level of safety and efficiency they bring. Definitely they bring the efficiency because they are very swift and they are time savers, they are safe as well at times when some supplies are to be emergently made to certain difficult places or at different difficult terrains. The use of drones is rapidly expanding to commercial and civil government applications like scientific, recreational, agricultural, product delivery. So, even in the field, drones are used to spray pesticides, right, and even by some e-commerce giants, drones are being used to supply food or your deliveries. Aerial photography is one such feature of a drone which has become a new trend, where even in the marriages in India, the aerial pictures are clicked of the marriage processions or functions. And then infrastructure inspections, drones are used for racing, policing, surveillance, firefighting and more. So, the military use has now turned into commercial and civil government use as well as private use, and which is why we have more legal questions arising. Drones are a common sight even in weddings across India, we all know that. Civilian drones now vastly outnumber their military counterparts. This everybody knows, because even the kids in India are using, or everywhere in the world they are using the drones as their toy. And military usage is there, but the civil usage of the drone has outnumbered the military usage over the period of time very rapidly. Delivery of healthcare items in remote areas is done through the drones, and for agricultural research activities, for crop assessments, land records, for spraying of insecticides and for nutrients, even the drones are used in India. If I tell you the glaring example of the use of the drones, rampant use of the drones by the government in India, it was in the lockdown period of COVID-19, when containment zones were supervised through drones, because there was a great fear of infection to spread even on the physical supervision or person doing the physical supervision. That is why drones were used by the government to look after or to supervise the containment zones in India, right. Then we have some more civil usages of the drones from Swamitwa, survey of villages and mapping with improvised technology in village areas, scheme of making out the Abadi areas to get residents property cards. So, nowadays property cards are given to the residents, and this scheme which did the survey of villages and did the mapping with improvised technology in villages was done by the drones in the very congested areas as well as in the far flung areas. Drone based surveillance system for railway security is also in place. Railway security is also monitored and assessed by the application or by the deployment of the drones in India. So, what is the regulatory framework of the Indian drone ecosystem? This is something which we are more concerned about here, and we are supposed to discuss in great detail. So far as the regulatory framework is concerned, there is no one omnibus law or a legislation or a guideline which basically regulates the drone landscape, and there are couple of more interesting issues, like there are various kinds of drones and there are different usages of the drones which pose more challenge to the legal measures as well as the regulatory measures to have a uniform answer or uniform solution to address or to cater to. So, let us have a look at the regulatory framework. In October 2014, there was brought a blanket ban on use of civil drones. Military drones were allowed, right, but the blanket ban was brought on the use of civil drones in October 2014 because of the abuse and misuse of the drones by some unscrupulous entities. But of course, this is one such technology or such medium which should not be curbed fully. So, it was realized by the government that curbing it fully will also result into some detriment. So, that is why they brought some relaxations slowly and gradually, and have also tried to regulate it fully, right. So, in April 2016, some draft rules were published, and ultimately final rules were not published, only draft rules were published in order to regulate the drones. In November 2017, again the draft rules were published, again the final rules did not come on drones. Then we have December 2018 development, where Digital Sky and CAR 1.0 regulatory framework with no permission, no takeoff was introduced. So, every person who wanted to fly a drone had to take the permission according to these Digital Sky and CAR 1.0. which is again problematic because civil usages of the drones are done indiscriminately by the people, and it is highly impractical for any person, or it is highly impractical to expect any person to take the permission and then think of flying the drone, or for using the drone for any particular delivery or for any services, right. In January 2020 there came another important development is there, which is enlistment of non compliant drones. So, the list was released wherein it was declared that following kind of drones are enlisted and they are called as non compliant. So, they cannot be allowed to fly. In March 2021, Unmanned Aircraft Rules 2021 with severe licensing terms were introduced, right. Unmanned Aircraft Rules 2021 with severe licensing terms. In August 2021, Drone Rules 2021 published ultimately, right, and in February 2022 there was brought a ban on import of foreign drones. So, people now are since February 2022 there is a complete ban on the import of foreign drones into India. In June 2023, policy for export of drones liberalized, because by that time we had our indigenous products or indigenous drones made by our own people, our own manufacturing industries. So, export policy of the drones was liberalized. Well, so far as the drone regulations and manufacturing and operations of the drones are concerned, this is something which gives you an idea as to how the drones, specifically the manufacturing of the drones and their operations are regulated. So, we have drone rules, drone amendment rules, certification scheme for unmanned aircraft system, carriage of drones in flights, import ban of completely built drones, export policy liberalization, etc. Right. Then another component or another aspect relating to promotion and scaling up of the drone, we have few regulations like new HSN codes, right, production linked incentive scheme, capital subsidy for Kisan drones, standard operating procedure for Kisan drone spraying, national US traffic management policy. So, this is again relating to promotion and scale up. Now, our government started promoting drones, and that is why even subsidies were provided and are provided to the Kisans if they buy drones and use the drones for spray of pesticides, etc. Right. So far as the training is concerned, even on training we have regulatory measures like drone training circular 1 of 2022, drone training circular 2, drone training circular 3, etc. and drone training circular 2 of 2023. So, there are circulars available for training. So, we have come to that stage where initially we were not having a very encouraging regulatory framework of allowing drones, but now we have come to that stage where we are even facilitating the manufacturing and operations, we are facilitating the promotion and scaling up of the drones, as well as we are training the people for usage of the drones, and some circulars are there for the training. There is a syllabus as well for training. Well, there is one very important act which needs mention here and which I think requires mention here, that is Indian Aircraft Act of 1934. This act lays a great foundation stone, or lays the foundation of it lays the foundation of any aircraft to fly, and drone is one such category which technically is an unmanned aircraft or an unmanned vehicle which flies in the air. If you look at the definition provided here in this act of the term aircraft, then even drone fits well into that definition or falls into that sweep of that definition. So, if you look at the definition, let me give you the definition and short title and extent of this act. This act may be called the Aircraft Act. It extends to the whole of India and to the citizens of India wherever they may be, and to the persons on aircraft registered in India wherever they may be, or it also applies to persons on aircraft registered outside India, but for the time being in or over India. It also applies to an aircraft operated by a person who is not a citizen of India, but has his principal place of business or permanent residence in India, right. Then when we see the definition, it reads that in this act, unless there is anything repugnant in subject or context, aircraft means any machine which can derive support in the atmosphere from reactions of the air, and drone naturally flies in the air, and it requires support from the air, right, to fly. It does not contain, or this definition has one exclusionary part wherein it reads that it does not contain such machines which fly in the air without the help of the air or the help of the reaction of the air, right, other than reactions of the air against the earth's surface. And it even includes balloons, whether fixed or free, airships, kites, gliders, flying machines, right. So, when we are in the law whenever the word means is used, it indicates that as if the definition is exhaustive in nature, right, because they haven't used the word includes. Had they used the word include, it would have meant inclusive, or it would have meant that the definition is inclusive. So, we have a clear idea that this definition is very exhaustive. So, whichever machine which flies in the air with the support of the atmospheric air, then that is called aircraft technically in the eyes of the law under the Indian Aircraft Act of 1934, right. So, there are certain more important provisions of this law which I believe require mention here. The central government has a power to exempt certain aircraft or class of aircraft or any person or class of persons, or may direct that such provision shall apply to such aircraft or persons subject to such modifications as may be specified. So, central government has the power to exempt certain aircrafts under this act, or some devices under this act with certain modifications as may be specified by them in the notification. The central government also has a power to make rules to implement the convention of 1944, and our rules which basically we have in place pertaining to drones, right. They draw their base, or you may say they are basically revolving on the power of the central government here, right. Then moving ahead, the Directorate General of Civil Aviation shall be responsible for carrying out the safety oversight and regulatory functions in respect of matters specified in this act. And what are the matters specified in this act? Even aircraft, right, is a matter specified, and drone automatically falls into this category, right. So, DGCA is the nodal agency under this act which has the responsibility of carrying out the safety oversight and regulatory function even of the drones. And we have Bureau of Civil Aviation Security, which shall also be responsible for carrying out the regulatory and oversight functions in respect of matters relating to civil aviation security. So, there are a couple of things which we will will require under the Indian Aircraft Act of 1934 for looking holistically what what is the regulatory framework pertaining to the drones in India. So, we can skip this part because it is not directly pertaining to drone, but these have bearing with the drones, because drones as per the definition is an aircraft, and it falls into the ambit of this law. So, whatever provisions are mentioned on the screen, they have the application even on the drones. The government has a power to detain aircrafts etc. under this act. The power is there with the central government to make rules for protecting the public health etc., to license the cancel the license of a person flying the aircraft, right, or to penalize people for flying so as to cause danger. So, whoever willfully flies any aircraft in such a manner as to cause the danger to any person or to any property or land or water or in the air shall be punishable with imprisonment for a term of 5 years, right, extend to 5 years, or some fine may be also imposed or levied. So, we have a particular law under regulatory framework, that is Indian Aircraft Act, which penalizes the people for causing any danger or for willfully flying a particular aircraft in such manner which may cause danger to the person or to the property, right. So, in case any drone which flies in the air and causes a danger to the property or to the person, then we have the provision which levies the fine as well as which penalizes with imprisonment. So, let us have a look at the basic legal infrastructure. As I told you that this is the parent legislation that is in place with regard to the control of manufacture, possession, use, operation, sale, import and export of aircrafts, which include the unmanned aircraft system, or in layman words drone. Drones are basically unmanned aircraft systems or unmanned aircraft vehicles. So, this is a parent legislation. When we talk about the legal structure here, the government also framed the aircraft rules 1937 in terms of the mandate of the act to provide for the detailed regulatory framework. So, under this act we have aircraft rules of 37, which are more exhaustive and more comprehensive in nature, and these rules have stringent provisions regarding the registration and operation of the aircraft, which is justified given the higher risk involved in the operation of the aircrafts. We have some pre-independence legislation. Even this 34 Aircraft Act as well as the rules, subsequent or consequent rules under this act are pre-independence legislation, but they have been amended from time to time, but they fail to recognize drones separately, due to which there was an elongated period of ambiguity and confusion relating to governance of the drones. Also, the remotely manned drones are substantially different than the manned drones, and therefore an evolved and more comprehensive legal framework was required for the regulation of the drone sector. So, we have now understood that we have a parent legislation in the form of 1934 Act, followed by the drone rules, aircraft rules of 1937. But since drones have not been separately recognized under this act, right, and there was long period when we had ambiguity regarding the control or regarding the regulation of the drones, and that is why comprehensive legal framework needs to be evolved pertaining to the drone sector especially. So, recent legislative and regulatory developments are also there, which particularly, or you may say which specifically deal with the drones, right, which are as follows. In August 2018, the DGCA, which is a nodal agency for maintaining safety and operations, for the first time issued the detailed requirement and compliance procedures under civil aviation requirement for remotely piloted aircraft system. However, these civil aviation requirement rules were not elaborate, and certain important aspects relating to national security were not addressed. Moreover, the requirements were restrictive for the new entrants, and special exemptions would be required for most of the use cases, which made it difficult for stakeholders to undertake research and testing of the drones. So, in nutshell, I will say that these August 2018 DGCA civil aviation requirement rules were not accepted or welcomed, because they had some limitations and some restrictive approach was there, and that is why stakeholders could not appropriately did the research and tested their drones, right. So, accordingly, the Ministry of Civil Aviation notified the Unmanned Aircraft System Rules in 2021, which are called UAS rules, Unmanned Aircraft System Rules. These rules were narrowly focused on addressing the national security concerns by toughening the licensing and approval norms. So, these rules addressed some national security issues which were unaddressed in the August 2018 DGCA CAR. But now UAS rules, Unmanned Aircraft System Rules of the Ministry of Civil Aviation, they focus on addressing national security concerns, and they have provided tough license norms and approval norms, which made them highly restrictive for other people. Hence, these rules garnered a lot of criticism from people in academia, startup, and users and other stakeholders, and even they were not welcomed by the people because of lot of criticism, and they were stated to be restrictive in nature, as they involved considerable paperwork, required permissions for every drone flight, and very few free to fly green zones were made available. So, again it was a restrictive you may say approach of unmanned aircraft system in the unmanned aircraft rules of 2021. So, to address these concerns of stakeholders regarding the restrictions, the government floated draft rules in 2021 and sought objections and suggestions from all the stakeholders. After taking into consideration the objections and suggestions, the Ministry of Civil Aviation notified Drone Rules 2021 in exercise of the powers conferred by the Aircraft Act, and these rules superseded the UAS rules. So, these are the latest to 2021, followed preceded by UAS rules, which were criticized. Through these rules, the government has considerably liberalized the regime on drones by removal of express restrictions on foreign owned and controlled Indian companies, by simplifying the drone registration and certification process, and by creating an online platform for approvals and airspace map by imposing lesser restrictions on nano drones, etc. However, these rules fail to deal with the privacy and safety concerns arising out of the drone operations in open sky. So, here again there are problems that these rules which were brought in 2021 after the criticism of the UAS rules were also not complete, because were also not adequate, you may say so, because so they also brought some restrictions, especially some shortcomings were there, like privacy concerns were not addressed even in these rules, drone rules of 2021, and though there were lesser restrictions on nano drones, but they could not cover or cater to the privacy aspects of the drone operations in open skies. Well, this is the recent development so far as the drone rules and drone law in India is concerned, and the framework pertaining to drones are concerned. We have some provisions under the Indian Penal Code also, which also makes a part of drone rules altogether, or you may say in a composite manner, including or entailing of course the Indian Telegraph Act of 1934, followed by the Aircraft Act of 34, and followed by the aircraft rules of 1937, and then development since 2018 in the form of aircraft rules brought by different agencies, by DGCA, followed by Ministry of Civil Aviation rules, and then finally drone rules of 2021. But we have punishments under IPC as well. Well, let us see few or couple of provisions of the IPC. We have section 287 of the IPC, which talks of negligent conduct on machinery. So, any person when uses any machine in a rash or negligent manner, see here machinery does not necessarily mean drone, but machinery may be any machinery for that matter. If any person is found using any machinery in a rash or negligent manner which endangers human life, they will be held liable for negligent conduct with respect to machinery. This section will be applicable in situations where a person is flying a drone and there occurs a technical failure because of which the drone crashes, thus causing risk of life to others. Then there is a punishment in the act of 6 months with the imposition of fine of 1000 rupees. So, we have a provision, that is 287 under the IPC, which states that anyone who is negligent or rash in using any machinery which is endangering the life or person or of anyone, then there is a punishment which follows, that is 6 months and 1000 rupees fine, or both, right. Then we have section 336 of the IPC, talks about what? Acts endangering life or personal safety of others. So, whoever does any act so rashly or negligently so endanger human life or the personal safety of other shall be punished with imprisonment of either description for a term which may extend to 3 months. So, we have one more provision, that is 336, which may also get attracted or which may also be invoked if anybody is flying a drone rashly or negligently and endangering human life or the personal safety of any person, and 3 months punishment is there under the IPC. Then we have one more provision, that is 268 of the IPC, which talks about public nuisance. A person is guilty of a public nuisance who does any act or is guilty of an illegal omission which causes any common injury, danger or annoyance to the public or to the people in general who dwell or occupy property in the vicinity, right, and which must necessarily cause injury, obstruction, danger or annoyance. So, any person who is guilty of a public nuisance, right, is covered under 268 by doing any act which causes any common injury or which even annoy you or which necessarily cause any injury or obstruction to you. So, even then 268 may be invoked, and if anybody is flying a drone and causing a public nuisance and resulting into some injury or obstruction or annoyance to any person, then this kind of a provision may be invoked. A drone might cause hurt as defined under 319 of the IPC. So, whoever causes bodily pain, disease or infirmity to any person is said to cause hurt. So, the person flying the drone, if the drone is causing physical hurt to somebody, then 319 will get invoked in that case. So, along with these offences, there is a high chance of criminal trespass as well as breach of privacy, right. So, any drone may do a criminal trespass or it may breach the privacy of a person. So, drones with a camera can be used to film people against their will or even bug them, thereby causing a breach of their privacy, which is very, very problematic, and which is you may say the most vulnerable side of it. Because what happens when your privacy is surveilled, or you may say private life is surveilled through some such unmanned vehicles or aircraft vehicles which have feature of a camera, then your privacy may get breached, and they may ultimately result into what? Into intrusion of your privacy. It may also be intrusion into your property, or you may say trespass of your property. So, trespass provisions may also get applied. Well, now coming to regulations relating to import of drones in India. As I said that in 2014, the government brought blanket ban on the import of the drones, but they liberalized export etc. slowly. The import of drones is prohibited in India as per section 80 of the Customs Act 1962. Goods which are prohibited can be detained, and according to section 233 of the Customs Act, prohibited goods mean any goods the import or export of which is subject to any prohibition. And under Indian system, the Ministry of Commerce and Industry, Department of Commerce, the Directorate General of Foreign Trade, vide their notification number this, has introduced policy condition for import of unmanned aircraft system, and it is a prohibited category. So, in the prohibited category, in the case of a prohibited category, the prohibited category can be detained if it is tried to be imported into India, right. Then there are a couple of more laws which may perhaps be handy, because there may occur an insurance requirement also. Drones are very costly and they may also cause damage to the third party, like a vehicle flying or flying on a road. The vehicle, unmanned vehicle in the form of a drone which flies in air, but may also cause loss to a third party. So, we have insurance requirements, or you may say third party insurance requirements. The rules and laws in the Motor Vehicles Act apply to unmanned aircraft as well, or unmanned aircraft systems. The insurance rules for paying for car accident damages also apply to drones. If a drone crashes and hurts someone or damages property, insurance will help pay for it. The rules apply in the same way they do for regular motor vehicles, and this is also necessary. So, in the legal framework pertaining to drones, we have insurance laws in place like Motor Vehicles Act, which applies even on the drones. Nano unmanned aircraft systems may operate without third party insurance. They can't cause much physical damage, because they are nano unmanned, very small in size, and that is why they do not fall into the category of this act, and they may operate without third party insurance. Otherwise, other drones have to take the insurance which are not nano. You can operate an unmanned aircraft system with special insurance for those operations. The Insurance Regulatory and Development Authority of India must approve the insurance product, right. So, let us see some use cases of the drones. Well, it is again very important. The Delhi police has admitted the use of the drones hired from open markets during the Delhi Assembly elections and devastating riots in the city in February 2020. Delhi police has used the drones during assembly elections, as well as during the devastating riots in Delhi in February 2020, but those drones were bought by the police from an open market. This is something very concerning here, because the open market drone may cause some data issues or privacy issues etc. But these are some use cases of the drones. Drones were used to monitor potential protests during the foundation of the Ram temple in Ayodhya. Well, this is a recent development where the drones were used for looking after the Ayodhya and its security during the Ram temple establishment, and they did monitor the potential protests or protesters, by aerial surveillance. Indian Railways have recently procured them to keep railway premises under surveillance. We have excellent uses of the drones here. Delhi police hired drones to conduct surveillance and collect data in the form of images and videos to ensure people were following lockdowns, as I discussed earlier, right. And Mumbai police or corporation have relied on drones to observe lockdown violations, etc. Drones were used by Punjab police in Amritsar to send alerts to the nearest police officer upon detecting individuals less than 6 feet apart, using a combination of artificial intelligence, location mapping and high definition camera, right. So, we have excellent uses. Similar projects using drones were commenced in Hyderabad and across Kerala, later even hiring private citizens to operate hired drones as part of the surveillance efforts. So, we have excellent usages of the drones. In Kerala, they included thermal imaging and video footage and was directly transferred to the phones of the local police. So, monitoring is advancing, surveillance is advancing, policing is made or is strengthened through the use of such technologies like drones. Haryana police deployed drones to drop tear gas shells on farmers protesting against farm laws near Shambhu border recently, right. So, we have wonderful usages of the drones, or you may say very significant usages of the drones in terms of national security, law and order, but at the same time the same usage of the drone may be detrimental to individuals' privacy or his or her you may say property as well as person. And India's drone regulations, which we have understood recently, as I said that they start with the Indian Aircraft Act and followed by the rules and some other rules up till 2022, which we saw. Let me not cover all of these again, because these we have already discussed earlier, but these rules have very exhaustive exhaustive and all encompassing regulatory features, right. We may skip because we had already discussed these. Now, this is very important for us to understand that on May 2nd, 2020, the Ministry of Civil Aviation announced a conditional exemption under the erstwhile aircraft rules and the CAR for government agencies. On May 8th, the Ministry of Civil Aviation launched the government authorization for relief using, that is called Garud portal, to fast track the conditional exemptions for drone sought by the government agencies. The introduction of the US rules in March 2021 replaced the erstwhile aircraft rules and CAR. Shortly after this change, in April 2021, a conditional exemption from the entire unmanned aircraft system was granted. So, in past 2 years, law enforcement agencies have conducted drone surveillance by consistently obtaining broad exemption from India's extant drone regulation. As a result, drone surveillance for policing has relied on good faith and contractual obligations as opposed to legal safeguards for data protection and privacy, which is a very important aspect. So, their modus operandi for tackling obligations under India's upcoming data protection law is basically what, that section 35 of the data protection bill, which is now a act, gives the central government wide powers to exempt government agencies from provisions of the PDP bill if deemed necessary on grounds including public order and state security. So, any government agency which is working for maintaining public order or state security, they are supposed they are basically exempted under this act as well, not to take not to be obligated by the obligations or responsibilities, very strenuous responsibilities or strenuous obligations of the Data Protection Act, and they are exempted from following the exact steps which a ordinary person is supposed to follow in the case of Personal Data Protection Act, right. So, government agencies are exempted if they are working in maintaining public order and state security. This act also requires reasons for these exemptions to be recorded in writing, right. And we further if you see, then we have very excellent judgment Justice K.S. Puttaswamy versus Union of India, wherein the government agencies may forcibly rely on exemptions from drone laws and data protection laws. So, in the cases of the government agencies using the drones for any purposes, specifically for the specified purposes of national security or public order, etc., they have the exemptions from the drone laws as well as from the data protection law of the country, and they are free to use. However, they are supposed to adhere to the threefold requirement for restraints on privacy laid out in Justice K.S. Puttaswamy versus Union of India, wherein one of the requirements for restraint on privacy under the K.S. Puttaswamy is that in the case of national security, or for that matter in the case of public order, the government agencies, investigating agencies may impinge or intervene into your privacy and may also access your data, etc. Right. So, coming to another aspect, the drone operations by government agencies must meet the requirement of legality, necessity and proportionality to their objectives, regardless of the exemptions obtained from any legislation. So, this Puttaswamy's ratio, right, this Puttaswamy's ratio shall still be applicable even on drone laws or drone regulations as well as on data protection, right, act, digital data protection, on both, and in the case, only in the cases of legality or necessity or proportionality, any government agency or any public agency is allowed to take liberty or exemption, and they may perhaps use the drone in any of the ways whatsoever which are otherwise restricted, So, thirdly, the government agencies must be prohibited from hiring and renting drones owned or operated by private citizens. Public procurement through the release of tenders and requests for proposals increase the transparency, and that is how only they can procure the drones. They cannot buy the drones from the public. The instance of the Delhi police buying the drones from the local market basically is problematic, or you may say is a violation of this particular rule. So, government agencies are supposed to buy it by inviting the tenders, etc. Well, invitations are offered by the DGCA for expression of interest to conduct experimental BVLOS operations, and BVLOS operations are basically what? Beyond visual line of sight operations of the remotely piloted aircrafts. So, on May 2019, the DGCA had invited an expression of interest, and many parties participated, and they submitted their expression of interest regarding the beyond visual line of sight operation of the drones. And some of the parties which are very well known parties like Zomato, Swiggy, Tata, right, Honeywell, Zipline, Dunzo, Redwing, they were shortlisted to provide additional technical details regarding their BVLOS application, that is beyond visual line of sight application. And what does this beyond visual line of sight means? That for a delivery of the products, for supplies, for surveillance of traffic, for construction, etc., the private companies may be allowed to use the drones. That is why, and that is why they were invited to submit their expressions of interest and submit their technical details regarding their application for starting usages of the drones in this manner, right. However, this willingness shown by the DGC and other concerned authorities to incorporate use of drones in the civil aviation ecosystem of the country was welcomed by all. Now, we have some rogue drone guidelines. In 2019, the Ministry of Civil Aviation also released the National Counter Rogue Drone Guidelines with an aim to address the perceived law and order and national security issues that are anticipated due to unregulated and unchecked operation of drones. The NCRD guidelines aim to bring out the various counter rogue drone measures. The scope of NDRD guidelines includes laying out guidelines for assessing the drone threat, creating awareness about the various technologies involved in handling drone threat, ready reckoner for anti-drone measures, understanding multidimensionality of drone threats, and website has also been launched for granting permission for aerial photography and remote sensing survey. Right now, we have a very dedicated website launched by our Ministry of Defence, by our Honorable Minister Rajnath Singh, and anybody may take a no objection certificate for undertaking a aerial survey with the final permission of the DGCA online through that website, right. And the portal will be used by various vendors engaged by state governments or by public sector undertakings in seeking NOC from the MOD. Through this initiative, the Ministry of Defence will be able to reduce the time usually taken in issuing NOC, because now it can be done online by applying on the website. And one time opportunity is also given for voluntary disclosure of unregulated drones. So, if any party or any individual has an unregulated drone, so one time opportunity is given to them to voluntarily disclose as to how many number of such unmanned aircrafts or such unregulated drones they have or they possess. And instances of unmanned aircraft or drones being operated in Indian space without complying with the drone regulations have come to the notice of the government. That is why the government has invited people to voluntarily disclose, right. One time facility was given and public notice was issued on January 13, 2020, right. Even prototype is not allowed to be unregulated prototype is not allowed to be flown, is not allowed to fly in the airspace. They have to disclose first and take an NOC. Additionally, such drones can be enlisted without having to comply with no permission, no takeoff requirement. So, according to this notice, for one time voluntary disclosure, person in possession of such non-compliant drones can submit the required information through an online portal as available here. The drone enlistment form for voluntary disclosure has several parts, which I am skipping because these are not required. Now, we have 2021 framework here, which we had discussed earlier, but we will discuss it in a more detail quickly. And so far as the unmanned aircraft systems in India are concerned, they fall into three categories, namely airplane, rotorcraft and hybrid unmanned aircraft system. They are further broken into subcategories as follows: remotely piloted aircraft system, model remotely piloted aircraft system, and then autonomous unmanned aircraft system. Unmanned aircraft system are also grouped into classifications. Classifications are based on the maximum all up weight including payload. The classifications are as follows: nano unmanned aircraft system, these weigh less than or equal to 250 grams. You do not require permits to fly a nano except in controlled airspace. You must ensure that you do not fly any nano drone beyond 50 feet or 15 meter above ground level. So, nano unmanned aircraft system you can fly without the permission or without any without any obligation, but what is to be taken into care is the fact that the weight of the nano craft should not be more than 250 grams and it does not go beyond 50 feet or 15 meter above ground level. Then micro unmanned aircraft system, these drones weigh over 250 grams, but less than or equal to 2 kilograms. No permits are required for recreational use, like for toys, for kids toys, etc. Even for commercial usage and flights in controlled airspace require. So, here particularly no requirement, no permission is sought or is required to be sought if the micro unmanned aircraft system is not about 2 kilogram in the category, and for recreational usages you may use those drones. Small unmanned aircraft system, these weigh more than 2 kilograms, but less than or equal to 25 kilograms, right. And we have medium unmanned which weigh up to 150 kilograms and large unmanned which weigh more than 150 kilograms. So, registration is required for all except the nano category. So, registration is required for even micro, small, medium, large except nano category where no registration is required. And what is the drone registration process in India? It is very simple. There is a application procedure for drone registration. Make an application in form D2 on Digital Sky platform along with fee specified in rule 46. Provide requisite details include the unique number of the type certificate of the unmanned aircraft system. Then the Digital Sky platform will verify the details. They will issue a unique identification number. The unique identification number of a US is linked to its unique serial number. It is also linked to the unique serial numbers of its flight control module and remote pilot station. If you change the flight control module or remote pilot system, you must update Digital Sky. You have to update the unique serial number of the new flight, or you must do so before you fly the unmanned aircraft, right. And then we have remote pilot certificate in India. You can fly drones up to 2 kg for non-commercial drone use without a pilot certificate. All other drone uses require a remote pilot certificate. So, up to 2 kgs you can do without remote pilot certificate, but beyond 2 kgs you need a remote pilot certificate, and it shall be valid and enlisted on Digital Sky. And there is an eligibility, an individual will be able to get a remote pilot certificate if they are not less than 18 years of age and not more than 65 years of age, if they have passed the class 10th examination or its equivalent from a recognized board, and have completed training for any any authorized remote pilot training organization. Procedure for obtaining this certificate is, you have to complete the training for your desired category, right, pass the test conducted by the authorized remote pilot training organization, and within 7 days of successful completion the training organization will apply for your remote pilot certificate, right. You will be issued a remote pilot certificate through the Digital Sky platform, but it is required only when you fly a remote you fly a unmanned aircraft above the 2 kg category, otherwise it is not allowed. Your remote pilot certificate is issued within 15 days, right. So, this certificate remains valid. A remote pilot certificate will be valid only if it is enlisted on the Digital Sky, unless suspended or cancelled, and it is valid for 10 years. It may be renewed for a maximum period of 10 years on payment, and there are certain exemptions from obtaining a certificate. No remote pilot certificate will be required for obtaining a nano unmanned aircraft or for a micro unmanned aircraft for non-commercial purposes. Well, all of this causes a threat to the individual privacy, and under the current laws, we have the good setup, like our Digital Data Protection Act, as well as our Puttaswamy judgment pronounced by the apex court, has given us a good regulatory framework and jurisprudence as to how to tackle it. There is a threat to cyber security as well, because drones might inject malware on frameworks, or they may disrupt the frameworks functioning, especially those frameworks which operate wireless protocols such as Bluetooth. Drones may cause criminal activities. In in other instances, can even use drones to create digital interruptions in facilities that are unreachable on foot or vehicle, right. By flying drones over these facilities, such disruptions may be caused. Security measures against human threats such as biometric scans are therefore futile against such cyber attacks. Drones can even be used to target people by providing spoof Wi-Fi access, right, and this threat is amplified by BYOD, bring your own device policy in the organizations. In the absence of security measures such as forestalled, we have clear threat on the cyber security, and drones have at times the bearing on the intellectual property rights. They are the creations of intellect, and they may be conferred intellectual property protection. Civil drones being extensively accessible could be easily tethered and duped by businesses, and some intellectual properties may also be violated. So, usually patents and some design rights may be conferred on the drones. So, the drone rules of 2021 allow for registration of various types of unmanned aircraft, and to support one's invention, the inventor can apply for patents as per the rules provided under the Patent Act, or for that matter under the Industrial Designs Act, right. So, it is always prudent to protect your intellectual property, as well as keep your design registration done, etc., if you are a maker of a drone. To conclude, I will say that there is a very strong and robust mechanism available pertaining to the drones, which is a blend of some exemptions and liberties, as well as strenuous conditions imposed on the application or on the usage of the drones in the airspace. I believe that our laws are constantly evolving and catering to several legal questions and problems pertaining to the drones in a very systematic manner, and in the years to come we will also witness some case studies on the drones. As of yet I haven't come across any case study. Kindly pardon me if I missed it, but there are no case studies available in the courts of law there are no cases available on the usage of the drones, but as and when the cases will come, we will have a jurisprudence also, or we will have a case study also. So, with this note, I thank you everyone for patient listening. Thank you very much. I will meet you again with more interesting lectures in this series called Law, Science and Technology.